Hello everyone. Thanks for finding this video again. I want to introduce you to our next unit. We're going to be looking at criminal justice and Supreme Court cases and other kinds of developments in American history that help us to understand that relationship between what we can and cannot do as it's interpreted by the Supreme Court, what the Constitution says, what it says through interpretation, and how that integrates with our popular understanding of who we are, what our DNA is, what it tends to be. So we're going to be taking a look at 3 or 4 of these videos in which we integrate the reading that you did and probably a lot of other things that you maybe haven't come across. So I'm going to be sharing a lot of things, and I'm just relying on you to have done the reading, so I don't have to elaborate too much on that. But again, I can always field questions in person or through email. But I thought maybe it would be helpful to start with this overview. We're going to basically stick to this over the next few videos here. We're going to look at causation. What is crime? Where does it come from? How do we frame it and conceptualize it? We're going to look at this sort of procedure and what happens, what the Constitution says about that criminal process, and then punishment. And as always, I'll try to raise questions and try to give some insights. But again, these are just highlights. These are just my versions. And I encourage you always to go back to the original cases and take a look at what they actually say, and then what some of the various sources I have posted on the Moodle page say about these cases. So the first thing I want to say, again, I just want to remind us that we're in a realm of basically no absolutes. That's the nature of law. As supreme and clear-cut as law tends to feel or seem, or we want it to be, remember, good, well-meaning legal minds disagree often about what the Constitution actually says or how it can be applied. All right, that's just standard. It seems clear-cut, but it's not. It's not as clear-cut as maybe we might think. There is a lot of agreement about a lot of kind of the majority sort of opinions about these things, but there are good controversies about those that draw attention to how we frame things like this and what baggage we bring to the law. So we're going to take a look at causation. And just very briefly, one of the things I wanted to just highlight is, again, going back to the sort of colonial era, some unusual kind of laws, or laws that might strike us as unusual nowadays. So the term crime can be defined by Webster, it could be defined by me, it could be defined by you, it could be defined by dictionaries or legal lexicons in different ways. It's a flexible term, usually for the violation of a law. So obviously, when we try to define what crime is, we have to kind of have a definition in mind about what law is. In colonial times, most laws reinforce public and private morality and values. So there's obviously this relationship between what the law is supposed to do, and then, of course, the crime is a violation of that. So an example of one of those maybe unusual kinds of laws, a category of law we don't tend to have anymore, is these sumptuary laws, which I mentioned before. These are laws made to restrict the presentation of luxury and extravagance. It's basically disappeared by the late 19th century when we enter into what scholar Thorsten Veblen called an era of conspicuous consumption. This is when people show off what they have with what they wear and what they buy. A student of mine a few years ago suggested this interesting idea, which I've been pondering ever since, is if we have a minimum wage, why not have a maximum wage? Why not have sort of a cap, a percentage cap on how much the wealthiest employee of a company, even if it's a CEO, can make, and to have that sort of proportionate to the lowest. That seems to be a very unpopular idea. Most people aren't even thinking about that, but that belies how common it is for us to consider it your right to show off your wealth if you want to. Right? It seems to be an American value. That's very different from how it was in the past. We don't really have those kind of laws anymore. But an intriguing idea, isn't it? So one of the questions I want to pose to you is there any real difference between sin and crime, or what we think of as sin and what we think of as crime? the essence that binds them together is that it's a codified, written down, and executed morality, right? The reason we have laws, it seems to me, is to produce a particular effect, to create certain types of behaviors that are more or less appealing. So it seems to be similar in what the definition of what sin is and what crime is. And of course, if we look at the Judeo-Christian influence of the Constitution, the origins of that, which are not the only influences, there's obviously an implied significance of sin and crime being related. All right, so another thing to think about is this. This is one of those big ideas. I'm going to simplify it and just give it to you in concentrated form. So, fascinating. So, this is a person who is not taught anymore that I know of, sometimes in social psychology. He's considered the father of sociology, which again is kind of, as a discipline, falling out of favor for some reason. But a man named Max Weber, who wrote a variety of different things, very interesting, in which he claims this fascinating thesis, which I offer to you here to consider as we think about crime and law. What Weber was saying is that the modern nation, the notion of a country, possesses a monopoly on the legitimate use of coercive force and violence. It's a really profound idea. What that really is saying is, you can create your own laws if you want. I can create my own laws. But probably no one's going to observe them, and you are prevented from executing them. You are prevented from punishing someone else for breaking that. The only body that can do that legitimately is the state. And by state, I mean nation. Right? The government can do that. No one else can. No body can. And I think it's embedded in this concept that we have of popular sovereignty, that in a sense we give up our individual right to create laws and execute them as individuals in the state of nature, as the contractarians would say. And we give it up through democracy or the republic to have this governing body do that for us. So again, that's kind of tenuous, but it does seem Weber's idea is a really profound one. What that means, what Weber's thesis is, and what that means is that the state has a monopoly on killing its citizens and killing citizens of other countries. No one else can do that legitimately. That's really profound to consider, right? Also, it's interesting that when we're thinking about crime and law, that the moral values or normative standards are often what we call putative, not always codified. So the things that we find valuable and important in terms of behavior are not always written down. They're not always codified. They don't always find a correlation in law, but they are putative. By putative, we mean the term suggests it's understood, right? So these normative standards are understood. We learn them. Maybe there's something embedded in us universally that prevents us from certain taboos. Just think of the worst concept that you could possibly imagine, and there's something, maybe you could make an argument that maybe God created humans to revolt at that idea, even though some might engage in that. There's some common understanding that we don't necessarily have to explain that is not always written down in laws. And pluralistic cultures, that is, cultures in which there are lots of cultures represented, cosmopolitan cultures, big cities that have a variety of diverse populations and worldviews represented, typically have different moral traditions than those that are what we call monolithic. So white Anglo-Saxon Protestants generally have a lot of similarities in their worldviews and behaviors. More sort of pluralistic or cosmopolitan, urban kind of areas generally have a whole variety represented. And so they have a different view on what is law and what is right. And so a lot of these sort of things have come to a head, these conflicts between what's right and what's legal, throughout different phases in our history. So the progressive era in the early 20th century, in times of crisis, sometimes this emerges after 9/11, And I'm thinking of the 80s and 90s, this idea where family values, quote unquote, and marriage and degeneracy started to become very politicized. So what does the law say about that? It becomes sort of the important issue. As Justice Oliver Wendell Holmes famously said, passing more laws only makes more crimes. And if you think about it, there's some truth to that, isn't there? If there are very few laws, then there are really few infractions, right? But if you have more laws, there are more opportunities to create more crimes. So those are things to consider as we go forward. I love that picture. There's an interesting little catch to this. Another thing that adds to the complexity of this, how we might view law and criminal justice, are what are called moribund laws. Moribund law, the word moribund basically means dead. It's like the laws don't really have any life anymore. So moribund laws, for example, can be found in this. This came up a couple years ago when there's a case that kind of became national here. In Florida, there was an 1868 law that's caused it to be a misdemeanor for a man and a woman to, quote, lewdly and lasciviously associate and live together before marriage. So, basically implying sex before marriage was against the law, which might strike us as odd now that you could even have a law based on that when we looked at privacy and kind of where our standards are in terms of culture and law. But that results in this man considering that his love is a crime. That's assuming that these two people are in love. So the idea, though, is this is an example of all sorts of dozens and hundreds of laws that are legally on the books, but they're not enforced. So really the laws come down to enforceability. Are there resources available to enforce them? Is there will to enforce them? So even though something might be technically an infraction of a law that it was written, 150 years ago or even 10 years ago, one of the questions comes down to the applicability of that. So that's an interesting thing to consider, that there are a whole bunch of laws that we just might not want to enforce, or that we might have resources prioritized for that. There might be other things that are more important. So in an age of a pandemic or invasion or war or economic crisis, we might not see those things as priorities, even though technically we could prosecute people on those. So that's part of the nature of law. That's always been the nature of civilization based on jus civile, is that these things are always kind of there to create a particular kind of behavior in society, and it always comes down to practicality. Who's enforcing these, and what are the resources available? Okay, so we're going to take a look at one of the readings that you looked at for this unit in just a moment. So take a look at that other the next video in this series, and we'll see you there. Thanks.